Many in Charlotte are wondering about the process of bail bonds right now. You recall that last week, Charlotte-Mecklenburg Police Chief Jennings criticized a magistrate for setting a shooting suspect's bond too low. So what guidelines, if any, do magistrates have to follow when setting someone's bond? Our Verified team investigates tonight.
The question, are bail bonds clearly defined for most offenses in North Carolina? Our sources, Chris McCartan with McCartan Law in Concord, and the North Carolina Judicial Branch. A refresher here, a magistrate is a judicial officer in a district court who performs duties in criminal and civil cases. A bond is otherwise known as a condition of release. Magistrates set bonds based on how likely the defendant is to show up in court and whether they're a danger to society. North Carolina judicial guidelines do not outline permanent bond amounts for offenses. Instead, McCartan says a magistrate can consider the current environment and trends when setting a bond.
I mean, classic example right now, weed. We had a discussion 15 years ago, somebody with a couple ounces of weed, it wouldn't be uncommon for them to have a $10,000, $15,000, $20,000 bond hung on them and being charged with possession with intent. Now, marijuana culture currently, no, you're given a citation and say, make sure you don't screw up your court date.
He also says magistrates won't even set an initial bond for some charges like domestic assault.
They're going to hang you with no bond for at least 24 hours. Let cooler heads prevail. No, a magistrate has broad discretion. In fact, that broad discretion is so broad that if somebody is held on a bond, it is generally understood that within between 24 and 48 hours, they have to get in front of another judicial official, an actual elected official.
So we can verify, no, bail bonds are not clearly defined for most offenses in North Carolina. Have a question for our Verify team? Send a message to the address on your screen.